So I think we have started. Welcome to our webinar on self-writing software, where we will explore who coded the string first and what the copyright concerns are with software created by AI. This event is organized by the European American Chamber of Commerce, New York. My name is Yvonne Bendinger-Rothschild. I'm the Executive Director of the EACC, and I would like to welcome you to our program today. So with all the hype around the opportunities and challenges presented by artificial intelligence, more and more focus is being paid on where the content is that AI is using actually comes from. And we've put together a panel to analyze or look into these growing number of conflicts between creators and companies that are training the AI system using data that doesn't belong to them. And those concerns were initially raised by a broad range of professionals, writers, artists, composers, and this group is now being joined by software developers. And practitioners and courts are trying to establish how intellectual property laws should be applied in cases of self-writing softwares. And we have an amazing panel today, which includes Louis-Pierre Gravel. He's the Vice President of the Practice Management Committee at FICPI, which is the International Federation of Intellectual Property Attorneys. We have Jeffrey Gluck. He's a partner at Pane Schwarzer. We have joining us from Spain, Victor González Pancherzo. He's an adjunct professor at IE University. And from California dialing in is Derek Slater, the founder of Proteus Strategies, who is moderating our conversation today. And with that, Derek, I'm handing over to you.
Great. Thanks, Yvonne. Thanks, everybody, for joining us. A lot to cover and unpack about generative AI and software code, and we'll touch on maybe some other subjects too. But maybe let's just start at the beginning, which is to say, what is generative AI? How does it work? How does it produce code? How does it produce software? What does that entail from a training perspective and more? And Victor, maybe you can help unpack some of that for us to just kick things off and level set.
Yes, absolutely. So what is generative AI? It's just a subfield of AI in general, no? And what's this AIs makes them special is that instead of the old AIs that we were used to know, they were algorithms and models that they learn to discriminate between different classes and to predict some outcomes that we will find useful, and it's been very useful. We can discriminate whether an image is a cat or a dog, something like that. But new generative AIs, they are doing something completely different, and they are generating. They are able to generate content. And I'm really probably if you are here in the panel, you know that's that difference. But the issue is how they do it, no? And what they makes different is that in the end, generative AIs are like in the end, it's every AI, it's a mathematical function, okay, that it's been trained with lots of data, and it's able to, in the case of generative AI, from some input, we will discuss about these inputs and the different data that you train that AI, it can generate something that it's new, or maybe it's not that new, no? It might sound familiar and so be like it's copying other authors' content. It might be, in the case of image generation, might be some images that have some copyright over there. It might be text. It might be code. No, it might be copying the code of other people. And probably the focus on the panel will be on that. No, and that's in that aspect. Maybe we can enter later on how they work and why whether they are copying or they're generating something completely new, but it's similar to copyrighted work.
Great. Anyone else want to add anything else on sort of the subject we're talking about, what it is we're talking about, how it works? I mean, just to sort of sum up, I think, and just to start with software, we can maybe talk at the end about images and other forms. But the way this works, as Victor said, is applied statistics. It's taking a look at large corpuses or corpora of software code, analyzing them to see what sort of inferences can be made about them. And then when somebody types into something like a GitHub Copilot or another service, trying to predict what makes sense as the next word or the next phrase or the next line of code, or what answers the prompt in the best way based on that statistical analysis. Jeffrey, you want to get in there as well?
Oh no, I'm
Okay.
I'm fine.
Fine. You came off mute.
I think you're doing a great job.
Thanks, Jeffrey. Appreciate it.
If you want, let me
Yeah,
just put you an example of how these algorithms are working. So in the end, you have these big machines, especially the AIs that generate code or generate text, are called large language models, are huge models. When we talk about large, we mean large. Okay, it's super big compared to anything else what we have been doing a few years back. So what these models do and how they work, in the end, let me put it in example of image creation, and then I can go to the example of text generation. But image generation, these large models are trained with so vast number of images scrapped all over the internet that what they learn, it's, as you say, Derek, it's a statistical way of finding the best output to the input that you ask. This input, it's by text, can be another image as well. And what they are generating, it's a statistically effect. It actually is generating, it's a function these models do. It creates a mathematical function that can generate any image in the world, infinite number of images with some boundaries. Okay, so with maximum image size, with maximum number of colors that a screen can represent, and so on, some limits, but virtually every single image. So we can generate images of myself with green face, myself with the style of Van Gogh, my face with the style of a Goya painting, and so on. And these mathematical functions can create everything depending of the data that they have been trained, depending on the input that you are doing. But in the end, what they are doing is creating something from scratch. And in the case of text, this large language model, they've been trained with text, corpus of text all over the script of the internet. And what they're doing is, as you said, in the end, they are what is the best next word prediction, no? And what they are able to predict is all the possible strings that go from the text that you asked. And they have some interesting properties that they are learning, some whether they are stochastic parrots or not, so it's just statistics, or they have some knowledge or some understanding of the world. It seems that there's some papers already that they seem to point to some vague indicators that they are constructing an actual model of the world, a real understanding of the world, but in the end, it's just statistics.
Right.
Yeah, go ahead, Jeffrey. Yeah.
I'm sorry, if I may add, at its heart, artificial intelligence, and particularly neural networks, are massively parallel pattern recognition engines. And so what they are doing is they've gone through their training, and what they're doing is they are coming out with what they recognize as being something that is in accord with whatever inputs were put in.
Yep. Yeah. And so I think Louis Pierre, do you want to share anything as well on this score?
Yeah, and I think the other thing I think it's important to understand in the context of this discussion today is that the models that we're talking about, the AI generators, the LLMs, the GPTs, they don't understand what they're doing. I mean, they are. It's a little bit reductive, but that's what it is. They are statistical tools. Based on an input, they will provide you with an output that statistically is what the formula tells it to output. They have no they don't understand the boundaries of what they're working in. They don't understand the code that they're creating. They don't understand the words or the images that they're producing. It really is a statistical model. And so the danger we have when we talk about some of these models is anthropomorphism. English is Thank you. That English is my second language, and I have a lot of difficulty with that word. But that's the danger is to try to attribute too many human attributes to it, because they really don't have any. And so when we look at it, then when we're going to start talking about the copyright issues, it's important to keep that in mind, because that colors the entire discussion going forward.
That's right, and that's why I sort of wanted to start this conversation with a grounding in the technology, because AI, is thrown out there as sort of, it can mean a lot of different things to a lot of different people. It does. It has a variety of uses. Generative AI is not AI for image recognition or, lots of other uses. But the core thing here that then we need to pay attention to for copyright purposes is what is going on here. It's not that this is a remix or a mashup per se, where you're sampling from this and just smashing it up together with that. Instead, it's reading and analyzing a whole ton of stuff to generate that statistical model, such that then when new prompts are given to it, it outputs something else. So, that's a long way of saying the sort of each individual item that's being read or analyzed isn't sort of being copied and then spat out, although the outputs may reflect what was in those initial inputs because of the statistical analysis. So with that as a setup, there's been, we'll maybe talk a little bit about the litigation specifically in the US against Copilot, against OpenAI and Microsoft. But before going into the details of that specific complaint, does somebody want to just sort of get into, now that we've talked about how it works, what are the ways in which this implicates or may implicate copyright law? Why might it be lawful? Why might it be infringing? Just setting out the arguments rather than picking a side.
Well, I can get us started.
Sure.
One of the questions is the first thing you started with, as Victor mentioned a moment ago, is that these models, these AI models, need to be trained on data. And the first thing is, are you training it on copyright data that is copyrighted? And is that a permissible use of copyrighted data? Then you get to the end, and what have you produced? You've produced something that's been produced with this training data in mind. And if the training data was subject to copyright, is the product, the output, also subject to the copyright based on the data that was used to train the model? So that's the view from 35,000 feet, so to speak.
Yeah, just to complement you, Jeffrey, I think it's yes, there's these 2 point of views. The first part is, okay, was the algorithm using copyrighted data to generate content? Okay, even though if the generated content is not copyrighted, it's completely new, something completely new. This is one issue. And how do you train that algorithm was with, and I think this is one of the issues of the discussion with many complaints that are being in image recognition, in image generation, in code generators and Copilot and so on. So are you using my code to train your algorithms? And the other thing is, what happened with the output of the system? No, it's generating an output that it's protected by copyright. No, it's a general, and many people, and just the point that I want to stress here, and Derek, you already pointed it a bit. So this is a statistical machine. No, it's a statistics machine that it's outputting something that has some statistical meaning for the algorithm, but that doesn't mean that it's picking the training data and just copying it. It's just a statistical artifact of the training data and the input that you got and the output have on that. So it's not that it's copying per se, but the output, it's similar to something that is copyrighted.
Right. So I think it's important to understand that between the training data, which builds up these models, there's a question of whether or not just scraping the internet or GitHub or whatever repository to get access to that data is in fact copyright infringement. And there is a precedential case. There's a Google when it was sued for copyright infringement when it did its open library project back in 2015. the court essentially said then, listen, this is fair use. It's not copyright infringement. Leave us alone. 2023, we've got a couple of lawsuits. You alluded to them, Derek, a little bit earlier. We'll talk about them later. But I think the question isn't completely settled, and certainly not when it comes to code. So that's one thing. The second thing is, and Victor articulated very well, is that when you're prompting one of these models to provide you some lines of code, it's not just copying what it saw before. It's actually recreating or statistically outputting a series of strings of commands based on some approximations or based on some statistical models that it saw previously. And so there's no direct act of, in fact, copying, but you're generating truly some new piece of code, which may or may not be, in fact, infringe or an exact copy of something that the model has seen somewhere else based on the functionality that it's asking for. So there's like a bridge there that doesn't allow you to draw a straight line between what it's seen and what it's outputting.
Yep. And yeah, I think that's very helpful to sort of delineate when we say, copyright concerns around, self or generative AI for code. We really have to break down each of these stages of theirs, as Jeffrey said, the collection of the data, whether it came from GitHub or just scraping the web or some other, scanning books that have code examples in them. There's that element, which is, a form of copying. Then there's the analysis of that data to form the statistical model. And then there's the stage of prompting and outputs. And there are, copyright analysis has to happen at sort of each of those different phases and implicates different sorts of things. And so, diving in there and thinking about let's just focus on the litigation here in the US. Louis Pierre started to talk about, some of the, claims that are being made about use of copyrighted code as an input to that training process, that collection and analysis part, and where there are, on the one hand, claims that this is copying and thus it's infringement, and it impedes sort of the works of the original creators. The counterclaim is this is a fair use. It's something that's transforming. It's using non-copyrightable elements. Does anybody want to sort of elaborate on that sort of the fair use argument that's being made when, look, something's being copied? Shouldn't it be infringing?
If I may, so I think in some way, and it's not the entire picture, but in some way, the fair use or versus not the fair use of training these algorithms, it's in part of, I think it's a matter of scale. When I told you that it's a very big, that they are very big models, it's in fact they are scraping or getting data from the whole internet. No? But what happens if a human, like any one of us, goes and imagine that I want to start drawing. I draw very badly, and I want to become a painter. What do I go? Is I go to the Prado Museum here, or the Thyssen Museum, or whatever museum I want, and I get inspiration from the styles of others, from how they work, how they create art. And so, and what I do, I sit on some bank, or I sit outside in the terraces, and I start trying to replicate that just for learning purposes, right? And then when I start creating my own bodies, if I'm a good artist, well, I will be creating my own style. No, that's why some Pablo Picasso said, no, it's good artists copy, great artists steal. No, and they creating their own style. They're creating their own style in some way. What's happening with these models is that their scale of the operations is so big and it's so automated and so fast, no, in which they are inputting so much information that no more human, and not any big group of humans, will be able to do that on real time. So the scale of operations is huge, no, and some people say, okay, so you need to pay me for access to my creations, no? In the same way that when you're learning to code, you buy the book, no, and you can learn from the book in a licit way. You're buying the book and you're learning and you're copying the code to create your own program and so on. But you also can download by piracy that book, or you can go to the library, to a public library. So the one thing is the sources in which you get to that information, which we can talk about that later as well. And the other thing is the scale, no? In how big is that scale? And I think this also is implicating some concerns from some people.
Yeah. Well, I'd just like to add to that in the United States, that issue has not been resolved yet, and in fact, at this time, there have been at least 3 class action suits filed regarding use of literary works in training large language models. And the courts so in the United States, the courts have yet to resolve this question.
Yeah, with the debate sort of coming down to, on the one hand, as Louis Pierre said, there is this precedent of copying a work for an intermediate purpose that you choose something else that is lawful can itself be fine. So doing the scraping, if your end use is lawful, okay. And we have these precedents like the Google book search case, but transformative use where they scanned the entire books, they scanned millions of books, but they didn't make the whole books available. They showed very small snippets and made them searchable. That was considered transformative and wasn't considered to impair the market for the work, where the market for the work is reading the book. Here the debate becomes, is this code that's being outputted, sort of destroying the market for the works that were created in the first place? And that's complicated because the works as a whole may be copyrighted, but they include many non-copyrightable elements, that is functional elements that are not creative expression themselves. And generally speaking, it's not competing directly with those works. It's not that it's spitting out exactly the same thing. But with code, it's very important that there's this clearly non-copyrightable functional element. I don't know, Jeffrey, if you want to get in on that.
Right. Well, the question there's a question when it comes to software about the very issue as to whether it is subject to copyright protection at all in U.S. law, and that is an error that stems from an error. Well, I'll call it an error. It's probably more of an oversight during the 1970s, when the United States Congress was under pressure to legislate something into the Copyright Act so that software would be covered. So they established this what was then called the committee on. I'm sorry, I have to. Well, it was the short version is called CONTU.
Yeah.
CONTU, and something on the committee on something about technical usage or something like that. And CONTU came up with a report. So what Congress did, apparently, and there's very little, if any, congressional record of exactly what happens. I have done some research on this and have found very little, if anything. But it appears that Congress took the CONTU report in whole and just legislated it into the Copyright Act. Now, what happens as a result of that is that parts of the Copyright Act include discussion of terms that have to do with software and code, and they introduced terms in parts of the Copyright Act, but they left one essential part of the U.S. Copyright Act intact, and that was section 102B, which states that if a work is functional in nature, it is not copyright eligible. And the problem we have here is that software, by its nature, it's a set of instructions. It's like a recipe. It tells a machine what to do. It is inherently functional. So there's and in recent litigation, that there was an 11-year-long litigation between Google and Oracle, and which finally made it to the Supreme Court. And the Supreme Court basically did not touch the issue as to whether the majority opinion did not even touch the issue about whether software is inherently is inherently functional, or actually whether it's subject to copyright protection at all. The majority opinion was based on, and said we don't want to decide the issue of the copyright eligibility of software. Instead, we're going to assume that it's copyright eligible and then rule on the other issue that was briefed in the arguments. That issue being fair use.
It's another fair use precedent that sort of leaned towards, even in cases where an entire work or substantial portions of a work is copied, it can still be fair use, which is going to be pertinent, I think, in this context. Along with other software precedents like Sony v. Connectix, which was about copying an entire set of software for playing games in order to create an emulator, something that actually competed in the market. Sega v. Accolade was about copying essentially an operating system so that you can make video games that could interoperate, that could play on that system in ways that the initial creator didn't intend, right? That was a sort of a use that affected the market in a sense for that original work, but the court said this is fine because it's additive, it's complementary, it's not a replacement. Just pivoting a little bit, so we talked through some in the US, the fair use discussions. I think one of the things that's interesting in the software code context of litigation that's happening in the US is it's actually, so far, not the end of the road, but it's been distinct from those about images, audio, literary works. Those cases on sort of traditional media have focused on copyright infringement. In contrast, the class action against GitHub Copilot, against Microsoft, against OpenAI for code doesn't have a direct copyright infringement claim. It instead focuses on sections of the Digital Millennium Copyright Act and copyright management information, along with a few other state claims. Does anybody want to unpack what's going on there as sort of the other sort of issue that's coloring the copyright dialogue around code in particular, and the other issues? Jeffrey says no, goes on mute. I can do my best. I just first, as we're trying to do the comprehensive roundabout for sake of comprehensiveness, the claim being made here is that a lot of code was scraped from GitHub, and people had put those works under open source licenses, saying you may copy and reproduce and remix this and reuse it, so long as you do these, such and such things. You maintain the license, you give me attribute, whatever it is, and that didn't happen here. And they're saying that simply by removing the copyright management information, that licensing information, that you're violating this very specific part of the Digital Millennium Copyright Act. It's a complicated claim because of the, the sort of the way the act is structured, where it's not simply removing it. Often there's intent, willful knowledge, the particular use, all that matters. But the claims weren't dismissed out, completely. Some of the claims were dismissed in the initial phase by the district court, but some of them were left intact and allowed to go through to further argument. Whether they're strong claims or not, I mean, maybe people want to opine, but I think it's telling that there wasn't a direct copyright infringement claim in this case, even though the works were directly copied. It might say something about the strength of those claims in the code context. Go ahead. If anybody wants to chime in.
Yeah, and I think another important thing to remember is that if they were using open source software subject to a viral license, such as the GNU, the GPL, the GNU public license, or a few others, that even restricts derivative works. So the question is, how far, how do you define a derivative work? In this case, is anything that that something like Copilot puts out a derivative work of the input?
I think, yeah, part of the challenge here, though, for the plaintiff, for the holders in that case, is the licenses only matter if copyright is triggered in the first place.
Right.
So they don't supersede limitation exceptions and fair use. And what GitHub can say is, we weren't relying on the license. We were relying on fair use. So similarly, there's a contractual claim in the complaint that says you violated a contract. Generally, open source licenses are not, they're not contracts, they're licenses. The claim you can make in response is copyright infringement, not contractual violation. And they can say, regardless, we never accepted it. We're not relying on it. So none of those terms apply.
Well, actually, I'm sorry.
I
Actually,
may-
a license is a form of contract. So
Yeah, but the claim generally made if you violate an open source, if you go into if you want to litigate and say you violated this license, is you make a copyright infringement claim.
yes,
If I may add something to just to spice a bit more the discussion and to add more edges to it, I think in the end what's happening is those licenses were not prepared for AI using your code to generate new code, no? Because I think it's very clear if you got an open source license and you are using it, just by using it, it can become viral. There are a lot of issues with some open source licenses that forces you to not just quote that I'm using this library, I'm not using this software, and also the software that relies on the software I'm using gets that's what you're talking about, the virality, no? The software
Right.
I'm writing that's calling to this open source software that has this viral, not all open source, by the way, softwares have these viral licenses. So since you are using it, it gets infected with the same library, so you're forced to make your software open source, okay? And this part is clear. If you are using this external software, this open source software with viral license, you have to liberate your software as well, to make your software open source as well, for instance. But what happens in the terms that you are creating software, okay, that resembles that open source software? This is one claim. But the issue and the discussion here is, no, I use open source software, but I'm not using it to make a software into production, to make a website, for instance. I'm using it to generate software that it might not even have anything to do. It's maybe just to operationalize a car, how works the sensor of a car. Even if I use an open source library for web scraping or for web understanding. So I think the claims here is you're using my software to learn, and I want you to get viral, or I want you to respect my clauses. But I think there was no clause, and that's my opinion, maybe I'm wrong, but there was no clauses prepared for these situations, no? And I think there's a discussion there in probably starting in the open source community, what are the new licenses that have to be created, and how we communicate with the creators of these models to allow or disallow the usage of my code for which purposes.
That's a good transition point on two fronts. One, it is a live issue, like the open source initiative, which sort of is a curator of, the open source definition, or at least a major open source definition, are going through a process of trying to define what is open source AI. Because AI is you can't just say it's code, it's the data that was used to train it, it's how it was trained, it's the output model. All those things together need to be open. So that's one live issue.
The parameters of the model as well. Yeah.
Yeah, you start to transition into what happened. We talked a lot about inputs and how these things are trained. What about copyright when it comes to the outputs? What if you put in a prompt and what comes out is something that resembles previous code? What do we do? What do we do then? I think that gets back to, I think, Jeffrey, some of the issues you raised about functionality. Is even if the code is similar, does that mean that it's necessarily copyright infringement? But even if it is potentially copyright infringement, would a license apply? And if so, how? Anyone else want to expand on sort of how to think about copyright issues when it comes to the outputs of things like GitHub Copilot?
Well, I think it's a very interesting issue. And when you talk about copyright infringement, especially when the source is this potentially copyrighted material in the open source code, for example, there's a lot of different steps that need to be met, a few hurdles to be able to arrive at whether or not the end product is in fact a copyrighted work in and of itself, and B, potentially infringing on a previous work upon which it's built on. So I think the discussion here is super interesting from that point of view. I'm going to put my patent attorney hat on, and I've heard functional about 100 times during this conversation, and I think one of the issues we have is that from a copyright perspective or from a more general IP perspective, we don't understand how to deal with software. On the one hand, it's written expression. Okay, so that copyright exists to that. On the second hand, it is like a recipe, sort of, but it's much more than a recipe, because you're not making a cake or making a sauce or making a roast. You're actually interacting with physical components within the computer to achieve a specific output. And so, I think based on the conversation today, I would say, look, we need to really start thinking about having our mindset on patent protection for pieces of software that are particularly functional. But I know I'm going to raise a whole bunch of ire on this call, and that's fine. But you're right. At the end of the day, you need to look at the output of this and say, well, is this copyright infringement of something that exists already? And it's not that easy to make that determination, even if you have access to the original source code. And in many jurisdictions, in fact, in order to determine whether or not there is copyright infringement, you need to have had access to the original work, right? Because it's an act of copying. Again, the AI models can break that link and say, I'm not copying it. I've looked at the training data. I've built a huge, gigantic statistical model. You ask me a question or you ask me some prompts, and I produce something that's out there. If it looks like something that I was trained on, it's purely by accident, because there's no link between the two. And I think that's where some of the generative AI issues are gonna turn on, is to be able to overcome that obstacle.
Right. Well, one of the problems is that in copyright law, it's like an absolute determination. Either you infringe the copyright of the previous work, or you don't, and it doesn't matter whether it's by accident or on purpose.
No, I understand that, but you still need access to the original work.
Yes.
And you are the user in the end, so you are not the one that trained the model. So, which is complicating a bit more the things. But just Louis Pierre, you use your hat, a lawyer hat. Let me put my innovation professor hat here. Okay, so let me try to put again a perspective of what's happening. Okay, and what might happen into the future. So in general, the purpose of you were talking about patenting software and so on, and in general, the idea of patents in general, they were invented to protect innovation. Okay, because it was a way to guarantee that the state will be guaranteeing your effort as a company to innovate. And there is a case, the typical case when when your competitor is copying you, it's getting much less effort, to replicate your they don't have to pay for these innovation efforts. And it's very clear, for instance, in the pharma industry. The difference in costs in time between the first pill, of a first drug, you take several years of research, of development, of trials over trials and different phases of trials, and it can cost you 10 years, 15 years, and billions of dollars to develop a new drug. So the new pill costs you a huge amount of effort, and you're taking a lot of risk, and you want to be protected because the cost of the second pill, it's not billions, it's cents. So the cost of copying another formula of a drug is much cheaper. So if you don't protect them, you will be hindering innovation for pharma industry. What happens in the world of software is that the cost of generating a new software, it's not so big compared to the cost of replicating it. So if you are copying a copycat of another software, you will realize that it's difficult to copy. First, you need to understand what were the decisions they make and why they make the decisions they make to code that software. But in the end, it will cost you roughly the same. So the incentives to protect software are much lesser than to protect pills or drugs. But what happens with prompting, with what happens with these AIs to generate software, and believe me, I'm using a lot. I've been programming robots, I've been programming systems for many years, and I'm using AI to generate code like ever, and I never been so productive, meaning that I never created so much code so fast than ever. So the cost of replicating is even loss. So this time now, okay, this difference is getting a bit bigger than before, okay? And we don't know what will happen. We are just starting with these technologies, but there's something that we need to think and to understand what are the implications.
No.
I never thought
Yeah.
Victor would endorse potential patentability of software during this call. This is great. I'm happy.
Not sure.
Not endorsing.
but-
I'm not endorsing
yeah,
directly.
yeah.
I just calling to. We need to think about it. We need to think what's
I
happening.
think these gets to these, we're getting at fundamental questions of what is the rationale. There's both what is the text of the statutes as they stand, but also what was the rationale for them. With that, I know we only have a little bit of time before questions. I did want to pivot a little bit to the international context. So we've talked a lot about the U.S. litigation, fair use, and that's not something that fair use is not something that is universal. Other sort of copyright systems work differently. Does anyone want to speak to sort of the state of play, both in Europe, where there are some text and data mining exceptions that are distinct, or Japan, or any other place? Anybody want to sort of canvass the globe?
Well, I think you're right. I think the copyright laws are slightly different between different jurisdictions. I think some copyright acts, at least in Canada, are modeled on the UK Act, but they're also modeled a little bit on the US Act. So we have this mismatch of inspiration. Here's that word again. That results in a copyright act in Canada, which provides some interesting results from time to time. This whole issue has not been tested before the courts right now, at least in Canada. I think in Europe, we're going to see probably some movement on that issue at some point because of the copyright directive, which was issued just a couple of years ago. And also, I think we're going to have some other issues between differences in approaches between continental Europe and the UK now that Brexit is official, because then the UK may decide to go a little bit on their own in terms of how they recognize and how they approach AI-generated copyrighted works, data scraping, etc. And we haven't even touched upon the Asian solutions, which are inspired by their own culture and regime of laws. So it's going to be very interesting, and I would not be surprised if it led to slightly different results from jurisdictions based on where the mining actually occurs, where the models are actually trained, and where the output is actually produced. These are all questions that are going to be canvassed and very interesting. And sorry, Derek, just I want to remind everyone that's listening to us, if you have any questions, please use the Q&A and feel free to intervene. This is a very free-flowing conversation, as you've seen.
Yeah, thanks, Pierre, for both those sentiments. Yeah, please put questions into the Q&A bit or in the chat, and we'll find them somehow. And yeah, I think you're right. Like we'll have sort of a natural experiment here. I think in many cases, the fact that there is a flexible, open, and an exception in the form of fair use in the U.S. has been credited with making the U.S. a leader in innovation and digital technologies. That's why companies tech companies have been able to grow and thrive here, and a lot of AI training is done in the U.S. because of fair use. At the same time, we will see other approaches, and it's interesting, in many contexts, that contrast, there's a really sharp contrast between the U.S. and the EU on the limitation exceptions to copyright. Here, there actually, as you said, there is an express limitation in the copyright directive in Europe that protects text and data mining, which encompasses broadly artificial intelligence training. It includes, for commercial uses, the requirement to respect an opt-out. But that opt-out has to be machine readable and easy to use, and so on and so forth. And that doesn't exist yet. So we'll see how that evolves and how that shapes the market. Anybody else want to opine on other? I mean, Japan has done their own sort of law here that is even more permissive. Other countries are taking different takes. Other people want to comment on the international environment?
Rather than the international environment, I would like to point out what you're talking about, this opt-in, opt-out into your data. I think it's something that we're going to see it sooner than later. No, it's in Google had these bots, these spiders that's crawling all the internet just to create the search results, and they have the internal algorithm to the page rank algorithm. Well, page rank was replaced with an AI. But they had the opportunity, they given the opportunity, if you are a website provider or you have your own website, you can just upload to your website an internal document, which is robots.txt. And you tell the Google crawler or the other search engines crawlers, what do you want them to do with your page? Do you want to appear on Google results? You want them to limit your website? You want to hide it? Maybe it's a bad idea. You want to be appearing in Google, but for some reasons you are able to opt in or opt out. What will happen with generative AIs will happen at some point. I'm pretty sure that will come up. That will have some AI.txt within which you are able to allow web scrapers that are training, gathering data to train the algorithms to whether to opt in or to opt. Actually, there's some for images. There are some open source image systems that are like Stable Diffusion, for instance, which is one of the most famous ones, that are allowing authors, creators, to opt in or opt out of the training of their data. And probably soon, that will take some time, but we will have some standards in the same image, in the metadata of the image, that you want them to use it for training or not. That's a matter of time probably, and that will be one technical solution, easy solution for this for solving this debate.
Yeah, that's absolutely right. I think we've seen that's a great comparison. We've on the one hand, these are all new issues. On the other hand, there's nothing new under the sun. I think that's part of when we talk about inspiration and how AI functions. Well, in this context, we had this sort of similar issue with search engines and things that index the web. Indexing the web to make it searchable involved making copies of web pages to analyze them. It's very much like the situation of AI. And what happened there was that to deal with concerns wasn't changes to the copyright law necessarily, but a voluntary standard, right? Something can be legal and still be kind of bad manners. And so robots.txt grew out of that. And robots.txt is basically respected by all commercial search engines. People who are doing archiving in libraries, they might not respect it because they're a library. They're doing archiving. And so it makes sense to sort of keep a copy of stuff. And that's been a more flexible approach than sort of the rigidity of copyright. Whereas Jeffrey said earlier, doesn't matter your intent, doesn't matter with all these sorts of things, it can be pretty strict liability. Anyone else want to comment on that, or international scene, or other issues? And again, please chime in with comments or questions rather, if you have them. We're happy to continue opining in this broad sweeping topic.
So I think it's important to go back to one of Jeffrey's interventions earlier on in the conversation, and that is a lot of the work, or a lot of the code, and talking specifically about code, a lot of the code is in fact distributed and available under a variety of flavors of different open source licenses. And so there is a non-negligible risk that when you ask an AI like Copilot to produce some code for you, that it does ultimately come back and generate something that looks a lot like something that is in fact protected or distributed under an open source license. But the problem is that the person who's going to be looking at this code doesn't know that. And so, I think companies have become very sophisticated now in integrating open source software and understanding the terms of the licenses under which the code is being integrated into their own code. They've built sophisticated inventory systems. They understand what code needs to be brought back to the community in its original or modified form, attribution, everything like that. Using an AI tool to generate that code, you've lost that link. And so you don't know that you are potentially infringing on the terms and conditions of an open source license that is based initially on copyright law. And so you are potentially putting your company or your product at risk if it does in fact incorporate code that is protected by a restrictive license. And so this notion of infecting the code with terms and conditions that are surprising and unforeseen can be a significant risk to a company. And so I think not just from a copyright perspective, but also from a license perspective, you need to be very, very careful when you're taking that code and putting it in lock, stock, and barrel into your production engine, because you may inadvertently be putting your entire business at risk.
Well said.
Yeah, I think that on the output side, certainly, one still needs to be able to do that diligence to make sure, like, is there some creative copyrightable expression that I might be infringing here? If so, do I have a defense? Am I protected by some other exception or limitation? And one of the things that's interesting to me is in this context is how it compares to current practice of software engineers, where a lot of cases already, pre-Copilot, like think back low 2 years ago, long ago.
Back on the old times, yeah.
Right, back in the old times when you had an issue, and what would you do? You'd do a Google search, but really you'd do a Stack Overflow search. You'd look for who has tried to address this problem before, and you'd look at Stack Overflow, and you might grab a snippet of code from there. And yeah, you'd want to you'd do some diligence, but how much diligence was done? So I think, we're sort of seeing existing practice amplified and brought into new light. Right or wrong, I think that's an interesting dynamic that's happening. Right.
And to add, yeah, go.
I'm sorry. This goes back to the roots of the Electronic Frontier Foundation and groups, and the Free Software Foundation and groups like that, which started back in the day when people who were writing software, for people writing software, it was basically the Wild West. If you saw something you could use, you used it. This is back in the 1970s, the 1980s. And those movements started to maintain the Wild West. You can't, you can't protect your code. Was the philosophy. There's still, as you were saying moments ago, that there's an element of that in addition to the open source, the viral open source licenses, there's still an element of that, practically speaking, among software engineers who are just looking for a solution and grabbing a snippet of code here, a snippet of code there.
And to add a bit more, just to maybe as a closing comment, and what you were telling about, okay, so who inspects the code, and how do you check whether you are infringing or not, no? And maybe without knowing it. So and we are amplifying the back old to the old days to go to Stack Overflow, but now it's less supervision because you're generating much code per hour, to put it in some metrics than before. But this is just the beginning, because what's happening now this last week, OpenAI released the code interpreter feature for ChatGPT, and I can tell you that I'm just starting to use it. And what it's doing, it's you do a prompt, you write a prompt and analyze this data for me, analyze this, create this, generate this functionality for me. And what it's deploying, it's auto-generating the code, but at the same time, it's deploying that code and executing it. And believe me, this is just the beginning. At this point, those agents are very simple ones, very small ones, just little snippets of code, which might not be very big, so not much risk of copyright concerns. But what will happen in a few years when these systems will be able to generate several agents at the same time, with everyone bigger size, interacting with them to generate whole systems that have much complex functionality. And I think these scenarios are going to be even more different than today, because you are not even generating you're not generating the code. The machine is generating the code for you and executing the code for you, and you won't even look to it because you will get so used to, and we're going to be so fast that we won't have time to generate this vast amount of time. Look about, for instance, there is every second, every minute in YouTube, it generated like 3 years of content in YouTube, right? What happens when in 1 second or 10 seconds, a programmer can generate millions of lines of code?
Yep. And I think, just in there, sort of, couple of copyright IP issues that come out. So one is, who's the copyright holder of code that was generated based merely on a prompt and then generated by a machine? The US Copyright Office has suggested, merely writing a prompt is not enough for copyrightability. It's not enough human authorship. Something more must be done mixed with that to get copyrightability. Exactly what that means is still a bit ambiguous, and the courts will have the final say. So that's one issue, that the code that's output might not be copyrightable because of how it was generated. Another issue is that we talked about sort of the potential for infringement in that code and what that might look like. Another sort of security issues, and security is sort of out of scope of this, but it ties in with, because to do research on security, you often need to make a copy and decompile and analyze something, and that can implicate copyright. But there's a whole bunch of analysis has been done. One, these can be used to help with security. You can, something like Copilot can help say, like, hey, there's a security bug, or hey, let me help you convert this memory unsafe code to memory safe code. So there's a lot of security benefits. On the other hand, if you're not diligent, it can spit out stuff with tons of holes, or it could be used for malicious purposes. One final thing, just tying it together, we talked a bit about opt-outs in the context of web scraping and spawning. It's where it will get tricky with code is, as we've talked about, a lot of code is functional. And so you could say, I want to opt out this whole software package that I wrote. Well, your software package might include some snippets of code that are not original creative copyrightable expression. You can't opt that out of sort of, no one can use this anymore. So the opt-outs are going to be particularly, I think, tricky to deal with in code. It won't be quite as clean as we're seeing with the image generators. That's a few thoughts of the things I'm paying attention to. Anyone else? We've got 3 minutes. Anyone else want to have a couple closing thoughts or additional thoughts as we wrap up?
Well, I think so. 2 points. One, following up on what you just said, I think the opt-outs is going to be very representative of what's happening right now with the right to be forgotten provisions in some jurisdictions. It's extremely difficult to get completely forgotten on the net because, as a person, you've got interlinks with so many other different people, and you've interacted on so many different websites. To actually remove someone completely is extremely difficult, and it's going to be the same thing for that code, not only for the reasons that you've mentioned, but for a bunch of other reasons. I think from a security point of view, from a conciseness point of view, from an efficiency point of view, that these engines are built on data that's out there on the web, but it's not. There's an underlying assumption that what's out there is actually good code, or it's actually efficient code, but that's not true. There's a lot of crap out there, and so being able to generate code that's based on not very solid code introduces a whole bunch of other issues in the resulting code that has nothing to do with copyright, but it's got to do with efficiency. It's got to do with security. It's got to do with authenticity of the end product. And so I think you need to be really careful, and that extends not just to generated code, but anything that is generated by an AI tool as we know them today.
I wanted to expand a little bit on it. Well, first of all, thank you, Louis-Pierre. Well said. I wanted to expand upon something that Louis-Pierre said a little bit earlier. He kind of touched on patent and then backed away from it. And I think one of the overarching issues that we're dealing with when it comes to software and code in particular, software code in particular, is a question of how do you protect it? Is there an appropriate way of protecting software? And I think that, at least in the US, we have not resolved this issue, and it is an ongoing issue, and I don't see an end in sight in the immediate future.
Fascinating discussion, fascinating discussion. And I think that I'm walking away with, this is just the beginning. And we will have more programs around AI and what it does. But what I think is, what I think is interesting is the quality check that came up. It both in terms of the input, meaning the data, and the output, meaning the code in this particular case. And what I think is also interesting is, like, who owns the copyright if the machine. Does the machine have a father or a mother? And if so, who owns the copyright, or will it be a free fall? Maybe copyright goes away when it comes to, to code. I don't know. But fascinating discussion. And with that, I would like to thank our panelists for sharing their insights on this. And if you have additional questions, and do reach out to us. Our audience members can reach out to us. We're happy to connect you to our panel, for follow-up questions. And also, looking ahead, we have a couple of really interesting programs coming up. We have a discussion with Paolo Gentiloni. He's the European Commissioner for the Economy. We have a new series, Meet Your Future Self. An executive will share what it takes to get to the top. We have a Sustainable Investment Forum that we're organizing together with NYSE. We have a program on net zero, and another seminar on the corporate debt market. All of those can be found on the website. And as always, we will be uploading the recording of this discussion on our YouTube channel, and you will find the link on our website. Thank you again for joining us, to the entire panel. Thank you, Derek, for moderating, and enjoy the rest of your day.